Airlines make such wonderful constitutional cases. Just after the Second World War, the Commonwealth government established the Australian National Airlines Commission, which operated its own airline known as Trans-Australia Airlines, or TAA. Because the Commonwealth government was limited in its constitutional powers, TAA could only operate on interstate routes and routes within or into a territory. This is because Section 51(1) of the Constitution limited Commonwealth regulation of trade and commerce to trade and commerce with other countries and among the states. In the 1970s, the Commonwealth wanted to increase airline services for Western Australia, and one plan was to have a regular service between Perth and Darwin. This was constitutionally acceptable because it involved trading between a state and a territory. The difficulty was that in order for the route to be economically viable, they needed to add an intermediate stop at Port Hedland in Western Australia. So they amended the legislation to include a provision that said the Commission may transport passengers or goods for reward by air or by land, or partly by air and partly by land, between places in the one state, for the purposes of the efficient, competitive and profitable conduct of the business of the Commission, or otherwise as incidental to the carrying on of that business. It was quite a clever way of trying to get around the Constitution. Essentially, they were saying that intrastate operations were allowed, but only if they were incidental to the main game of interstate trade. This would make the intrastate route from Perth to Port Hedland acceptable because it was really part of the longer route to the Northern Territory, which couldn't operate without the intermediate stop. Western Australia challenged the law, arguing that the Perth to Port Hedland flight was entirely within Western Australia and was beyond the power of the Commonwealth. The High Court agreed. Justice Stephen undertook an extensive review of the authorities and quoted Chief Justice Barwick in an earlier case, saying, "The fact that international or interstate carriage by air may profit by, or to a significant degree depend upon, the level of intrastate carriage by air did not warrant the conclusion that the Commonwealth might stimulate and encourage the latter so as to foster the former." The court therefore confirmed that the trade and commerce power under the Constitution was very limited when it came to authorising intrastate trade.